A subscriber has asked me what the discovery process in civil litigation is and how long it lasts. That's a really good question, and I'm going to answer that in just a moment. It used to be, before the Federal Rules of Civil Procedure came out in 1938, and even for a number of years after, that trial was trial by ambush. Neither side went into the courtroom knowing what the other side had on them. So if the plaintiff had a serious DUI, that might not be known. And if the defendant had, harmed 3 or 4 other people in the same way, that might not be known. Internal correspondence in these big corporations, a lot of times that information never came to the forefront. But the discovery rules changed all that. Let's talk a little bit about several specific procedures that lawyers use to get information in the course of a lawsuit. The first, and probably the first one ever utilized in a lawsuit, is called the interrogatory. The interrogatory are a series of questions, and they are limited in number by the Federal Rules of Civil Procedure, although in certain instances, lawyers do get the opportunity to ask more. The interrogatories are questions propounded under oath, which means that when someone answers them, they have to swear that they're telling the truth, the whole truth, and nothing but the truth. Usually, these interrogatories are related directly to the claim or to the person bringing the claim. For example, someone might ask in an interrogatory question, "Have you ever been arrested?" Now, that question, even if it's answered, is not going to be admissible at trial because arrests are not admissible at trial. But the rules say that a lawyer can ask questions that are designed to lead to the discovery of other information that is admissible. So, for example, a felony conviction, sometimes a misdemeanor conviction, can be used as evidence in order to impeach the testimony of someone who acts as a witness. So even though that can't be admissible at trial, it can still be asked in an interrogatory, and it has to be answered under oath. Now, it's important to remember here that almost always these will draw objections, and the objections are designed to keep them from being useful at trial. However, just because somebody objects doesn't mean they're not going to the court is going to allow them not to answer. So oftentimes what will happen is a lawyer will interpose an objection that says, this information seeks discovery that's not admissible at trial. Plaintiffs object on the basis of its inadmissibility, and as a result, they refuse to answer. When the defendants come back and say, "We want you to answer," and the court says, "Yeah, you need to answer this interrogatory," then they repeat the same objection and say basically that subject to that objection, plaintiff was never arrested, or plaintiff was arrested but never convicted, or plaintiff was arrested and convicted. Whatever the answer is, the answer has to be truthful. So, interrogatories are a way that you get information about the person or the claim. Was the light red? Was the light green? Was the light yellow? In a traffic accident, for example. Do you have insurance? That's another question. Not admissible at trial, but it's admissible to allow the lawyers to figure out whether or not there is a fund of money there in order to pay the damages if they are successful. So interrogatories, that's one tool. Hey, Tony DeWitt again. Just a quick reminder, in the event you've made it this far and you still haven't smashed the like button, now's the time. The next tool is called the request for production. And this is something that you see used a lot of times with regard to defendants. A request for production basically asks a company to produce all of the documents related to a specific subject. So, for example, if the case involves a dangerous drug, the request for production may very well ask for all the information that was submitted to the FDA in order to get the drug approved. And if the person doesn't object, then they will produce all of that information. And usually it's more information than lawyers can actually look at. Also, in recent years, the electronically stored information, or ESI, has been a hot topic among lawyers and judges. And ESI are things like emails and other documents that are saved on hard drives. And so there are companies that have basically sprouted up from nowhere to help people search on the hard drives and information networks of companies to find documents and data that may be relevant to a particular claim or defense. So that's what a request for production does. It asks for those documents. The next tool is a request to inspect. For example, to allow someone to inspect a car that was involved in an accident, or inspect a guardrail, for example, that injured somebody. These requests are designed predominantly to allow lawyers to bring experts and have those experts measure and check and come up with theories about, or prove the theories of, those experts as it relates to that particular device. Or in the case of a premises liability claim where someone fell on a sidewalk, it allows somebody to come in and photograph the sidewalk. So those are the sorts of things that a request to inspect has anything to do with. And finally, the last tool is called a request for admission. And the request for admission basically says, admit that on January 5th, 2020, you owned a Honda Odyssey. Admit that the Odyssey was blue in color. Admit that it was traveling on Highway 101 at 50 miles an hour at 9:15 in the morning. Those sorts of things. A series of questions that establish baseline facts. They take those facts out of contention. In other words, there's no more dispute about those facts. And that helps later on in dispositive motions. And I'm going to do a video specifically about that later on. But that's what the request for admission does. All of those set up the final type of discovery, which is the deposition. A deposition is the taking of testimony in front of a court reporter by the lawyers who are involved in the case. So, for example, the plaintiff might take the deposition of a defendant doctor who is alleged to have been negligent and ask him all the different questions about what happened on that particular day. And the defendant doctor's lawyers may ask to take the deposition of the plaintiff and find out what they told the doctor, when they told the doctor, what actions did they take, for example, that may have contributed to their own injury. All of these questions are under oath, and you have to tell the truth. And lawyers are there, and lawyers make objections, but there's no judge there to rule upon those objections. So usually the rule is that even though a lawyer objects, you have to answer the question unless a lawyer instructs you not to. And the lawyer's not going to instruct you not to answer the question unless it is either harassing or it invades a privilege, something that you learned from your lawyer, for example, or that you told your lawyer. Now, you may have told your lawyer that you were driving the blue Honda Odyssey, and that's not privileged. The fact that you told him that is privileged, but the fact that you were driving it is not. So, although the tobacco companies for many years tried to cloak things under attorney-client privilege simply by virtue of having them been reported to a lawyer at some point, it doesn't actually work that way. So all of those things go into how a case is framed for trial, how evidence is gathered, how lawyers put together a case in order to try it in front of a jury. Now, the next question, and probably the one you're most concerned about, is how long does all of this take? Well, it depends on the number of defendants and the number of lawyers. For example, if the defendant doctor has a lawyer that represents him personally, as well as the lawyer that's been appointed by his insurance company, then there are two lawyers on that side whose schedules have to coincide to take the deposition along with the plaintiff's attorney. So it may take 2 to 3 to 4 months sometimes to get a deposition date that works for all the parties involved. And when that happens, it can take a long time to get the depositions out of the way. And then, once the depositions of the fact witnesses are taken, the depositions of the expert witnesses have to be taken. And again, that can take 6, 8, 10 months sometimes to get that done. If there are multiple defendants with multiple lawyers, then again, it can take quite a while to get these depositions taken. As a general rule, it's good to plan for a discovery phase in most civil litigation of at least 1 year. That probably sounds like a long time, but in terms of litigation time, it's almost the blink of an eye. I know lawyers who've been trying cases or are getting ready to try cases for almost 4 years. And I myself went through one with Ford Motor Company where it took almost 6 years to get to the point where we could get a final judgment in that case. It takes time, but it's worth the effort. If you've enjoyed this or you found it helpful or interesting, I would appreciate you doing 2 things. First, smash that like button. It makes you feel good all over. It doesn't cost you a thing. And the second thing, click the subscribe bell and the subscribe icon so that you can be notified whenever we produce a video and release it here on YouTube. Thank you for watching and have a terrific day.